Thank you, Mr. Chair and members. I'm here to present AJR 30, which calls on Congress to convene a constitutional convention for the purpose of amending the U.S. Constitution to impose fiscal restraints and limit the power of the jurisdiction of the federal government. The sponsor of the resolution believes the federal government is operating far beyond the scope of its legitimate constitutional powers, which has eroded the public policy-making powers of the states. This abuse of power has also created national debt over $17 trillion, and that is a real threat to our national security and the ability to future generations who to live as free and prosperous people. Current law, through Article 5 of the U.S. Constitution, empowers state legislatures to act collectively and act as a check to the federal power. A state-led convention gives state legislatures the same power as Congress to address the fundamental national issues through its amendment process. The convention is triggered upon the application of two-thirds of the states, 34 states in our situation. State delegations meet at the convention to consider amendments designed to address the particular issues outlined in the state's applications. Voting by the state, which is each state casting a single vote. Amendments are supported by the majority of the states, which will be ratified with 3/4 of the states, meaning 38 states, in order to become part of the Constitution. Georgia, Florida, Alaska, Alabama, Indiana, Tennessee have all passed similar measures, and Oklahoma just passed this morning. Here with me to testify is Mark Meckler, the president of Convention of States, and Grant Grayson, a young man who believes the Convention of States is important to his future.
Thank you. First witness, please.
Good morning, Mr. Chairman, esteemed members of the committee. Thank you for your time this morning on a very busy schedule. As an attorney, I actually enjoyed the discussion on the bar, probably less painful for me than you guys. We're here to talk about the role that California plays in the governance of Californians. Call of a convention is something that this legislature has supported by overwhelming majority in the past. In 2014, this legislature passed AJR 1, which called for a convention on a particular subject. This is a similar type of application, calling for the same procedures, the same safeguards are in place, the same measures for calling the convention, approving that call, and for limiting a convention to the called matters, and also the same procedures for ratification. So much of the debate that was had during the debate over AJR 1 has been had in this body. I realize you'll have some different membership, but I just wanted to refresh your memories. The main purpose of this application is to reset the balance between the states and the federal government. As a lifelong California resident, I grew up in Los Angeles in Southern California, now reside in Grass Valley, California. What I've seen over my lifetime in this state is much of the state's power over matters that affect our citizens has been drawn away from the California legislature, where I place my trust, and put in people in Washington, D.C., who are thousands of miles away from us. Even our own legislators often reside majority of their time thousands of miles away from us. And there has arisen a disconnect between California and the other states and the federal government. 72% of Americans today, that's nonpartisan, 72%, say that the federal government does too much and intrudes too much on our lives. Americans, by overwhelming majority, support their local governance, support their cities, their counties, support their state governments, but not the federal government. Congressional approval is at an all-time low. So it is time for the states to rise up on an individual and collective basis to take their power back, their rightful power from the federal government. The federal government was originally granted limited enumerated powers so that esteemed members of legislatures like you could decide the policies that affected the citizens of their states. Today, that's what we come before you, is to ask you to step up, to join with the 7 other states, including Oklahoma that just passed this today, and to move towards the 34 states, calling for a resolution for a convention of states to discuss fiscal responsibility, to discuss limitations on the scope, power, and jurisdiction of the federal government, and to discuss the potential for term limits for members of Congress and the federal judiciary. Now, you'll hear a lot of opposition come before you today and talk about the idea of a runaway convention. I think you've already dealt with that in the 2014 session. It's also important to know the origin of those arguments. They come from an organization called the John Birch Society, decades ago chased from reasonable political discourse for issues of racism and anti-Semitism. So I think those arguments are long discredited, and especially before this legislature. And with that, I'd ask you for your support.
Thank you. Next witness, please.
Hello, my name is Grant Carson. I'm a 16-year-old high school student, lifelong resident of California, and a proud American. I have been blessed to travel throughout this great nation, and in the journey, I've learned the true history from our founding to the present. Walking in the footprints of our founding fathers and heroes has been greatly influential and encouraging as I explored Plymouth Rock, Colonial Williamsburg, the North Bridge, Freedom Trail, Mount Vernon, Gettysburg, Washington, D.C., the Lincoln Memorial, the Liberty Bell, the Arlington, Virginia Cemetery, and many others. Along the way, meeting wonderful people from all cultures and ways of life has been significantly impactful. I'm concerned for the state, country, and my future. The federal government is out of control, which is self-evident with its astronomical spending, $19+ trillion debt, overregulation, and interference with the states, including California. Such issues as jobs, healthcare, education, natural resources, water rights, federal lands, and security all come to mind where Washington, D.C. continues to overstep its constitutional bounds. I support AJR 30 for the Convention of States because all these issues will negatively affect my generation's ability to prosper. And in this process, I would encourage the repeal of the 16th Amendment to the U.S. Constitution so the states may control their own finances. I implore you, as our state legislators, to fulfill your duty and restore and protect the constitutional powers that belong to California and the states. Hope for my future and generation, the state of California, and the United States of America is at hand. And Article 5, Convention of States through AJR 30 will preserve liberty for us all. And here with me today, I have over 30,000 signatures from people all around California and about 20 signed by people here today. So thank you so much.
Thank you. Anyone else in support, if you could come forward and just give your name and your affiliation. We are not going to take any further testimony in support.
My name is Stuart Dodge. I am also a lifelong Californian, and I am for AJR 30. Thank you.
Bonnie McAdams. I'm a lifelong Californian from Auburn, California, and I support AJR 30.
Kathleen Jenkins, representing District 7. I'm also for AJR 30. Thank you.
Sarah Carson, Roseville, California, and I also support AJR 30.
John Carson, Roseville, California. I support AJR 30.
At age 16 in Mumbai, I began reading about the American Constitution and democracy in America by
Sorry,
Alexis
we're not
de
taking further
Tocqueville.
testimony, please. Just give your name.
I reside in
Okay.
District 75 in San Diego County. Thank you very much.
John Owen, Colfax, California. I'm in support of AJ 30.
Mark Minicuch, Colfax, California. I'm in support of AJ 30.
Rick Raymond, Manteca, California, in support of AJR 30.
Lauren Bronson from Lompoc, California, in support of AJ 30.
Steve Komatowski from the Great Republic of Rough and Ready. I am in support of AJ 30.
Karen Jorgensen from Kerman, California, and I support AJ 30.
Dorda Jensen from Davis, California. I support AJR 30.
Bruce Arthurs, San Jose, California, and I support AJR 30.
Roger Miller, Martinez, California. I support AJR 30.
Margie Wilhelm from San Diego, and I support AJR 30.
Philip Feeney from Oceanside, transplanted from Boston 10 years ago. I support AJR 30.
Clayton Smith, Rancho Cordova, District 6, United States Air Force veteran and volunteer state director for the Convention of States. I support AJR 30. Thank you.
John Morley from Tracy, California, a firefighter paramedic, and I support AJR 30.
Thank you. Anyone else in support? Oh.
Joanne Martin, Roseville, California, and I'm supportive of AJR 30.
Alzada Knickerbocker from Davis, California, and I support AJR 30.
Tim McAdams, transplant from New York. I support AJR 30.
Carolyn Fanner, originally from Virginia. I support AJR 30. Thank you.
Thank you. Anyone else in support? Seeing none, opposition.
Good morning, Mr.
Please.
Chair. Oh, excuse me.
Go ahead.
Mr. Chair and members of the committee, I'm Trudy Schaefer, representing the League of Women Voters of California. Members of the League of Women Voters across the country conducted a study of amending the Constitution and of the Article 5 convention process just last year, and we reached consensus on many of the issues involved. As you've heard, there are many unresolved questions, and as your analysis points out, many unresolved questions about the powers and processes of an Article 5 constitutional convention. The League believes that a convention should be called only if certain conditions are in place, and among those are, we believe that the representation should be based on population, not rather than one state, one vote, that delegates should be elected, not appointed, as they are representative of the citizens. Voting at a convention should be by delegate, not by state, as delegates from any one state could have varying views and should be able to express them by individual votes. The League believes the convention must be limited to a specific topic. It's important to guard against a runaway convention that considers multiple issues or topics. Regarding constitutional amendments in general, we believe that a matter that is to be addressed by a constitutional amendment should be of acute and abiding importance, and it should make our system more representative, democratic, or protective of individual rights. It should not be on a topic that would be better treated and more likely to succeed through legislation or political action. So in light of these criteria, we must oppose AJR 30. You've heard the description of the measure, and it does not fit with what we believe the criteria for a process should be. Especially while claiming that the convention would be limited to a single topic, amendments that impose fiscal restraints on the federal government and limit the power and jurisdiction of the federal government, that topic is so vast that it could include numerous and diverse subjects. You've seen our list in the committee analysis. Everything from gun rights and Social Security to the entire military budget and defense spending. It would be a potential for a runaway convention. In addition, the resolution does not meet our criteria for potential constitutional amendments, as we feel it does not make our system more representative or democratic, and it does not protect individual rights. Further, as an organization that has studied a number of issues through the years, the League can only support amendments that advance and conform to positions that we've established by study and consensus. And for example, we believe that federal fiscal policy should provide for adequate, flexible funding of federal government programs. We oppose a balanced budget amendment because it would dangerously upset the federal balance of powers and hurt the economy. We favor reducing the federal deficit, but this should be accomplished primarily by reductions in defense spending through selective cuts and by increased revenue through a tax system that is broad-based with progressive rates. That's just one example, but it is one of many reasons why we must oppose AJR 30, and we ask for your no vote. Thank you.
Thank you. Next witness, please.
My name is Judy Kaler, and I'm with Eagle Forum of California. The Convention of States group says that George Mason proposed the Article 5 Convention solution to give state legislatures a remedy to restrain federal overreach. That's not true. George Mason never said that. The Convention of States made it up. James Madison kept a journal of what happened at the Federal Convention of 1787. Madison's journal shows that on June the 11th, 1787, George Mason said, quote, "The plan now to be formed, which is our Constitution, will certainly be defective, as the Confederation has been found on trial to be. Amendments, therefore, will be necessary, and it will be better to provide for them in an easy, regular, and constitutional way." So George Mason agreed with the other delegates that the purpose of amendments is to remedy defects in the Constitution. And I gave you some handouts. That's the first one. Remember, Mason and the other delegates had just spent 4 months creating a Constitution which delegated only a handful of enumerated powers to the federal government. So when the federal government usurps powers not delegated, they're ignoring the existing limitations on their powers. Would an amendment which says if a power isn't delegated, the feds cannot exercise it work? Well, no, we already have such an amendment, the 10th Amendment, and everybody ignores it. Our problem is a disobedient federal government. It defies logic that the solution would be to change the very document that the government disobeys. There's only one convention for proposing amendments. It's an Article 5, and Congress calls it. The chart, which is the second handout there, submitted for the record, explains who has the power to do what under Article 5 of the Constitution. The only power state legislatures have under Article 5 is to ask Congress to call a convention, period. Article 5 delegates to Congress the power to call a convention. Article 1, Section 8, last clause, gives Congress the power to make the laws necessary and proper to carry out its power to call a convention. This would include organizing the convention. But once the convention is convened, the delegates, as direct representatives of we the people, have the inherent right to alter or abolish our form of government as expressed in the Declaration of Independence, paragraph 2. The Federal Convention of 1787 was called for the sole and express purpose of revising the Articles of Confederation. I'm almost done. I'm really almost done. Can I finish? And that's the next handout. But the delegates ignored that and wrote a new constitution with a new and easier mode of ratification. And there are constitutions waiting in the wings for a convention. And the new state's Constitution of America dissolves the states. Thank you. We ask for your no vote because AJR 30 risks the Constitution and won't solve the problem.
Thank you. Next witness, please.
Yes, I'm Jan Collins. I'm a director of the Institute for the Constitution in California, and I'm from Grass Valley, California. Our Constitution delegates very few powers to the federal government right now. The rest are reserved to the states and to we the people. Amendments suggested by the COS will most likely expand the federal government and change its design from one of enumerated powers to general powers, limited only by amendments. COS says they have a solution as big as the problem. In fact, they have a solution that has nothing to do with the problem. The Constitution isn't the problem. The problem is that people are ignorant about our Constitution, and therefore it is not being enforced. What did our framers really say we must do with the federal when the federal government usurps power? They never said when the federal government ignores the Constitution, amend it. They never said file a lawsuit and let a federal judge decide. Instead, in addition to electing faithful servants, they advised interposition and nullification. Hamilton, Madison, and Jefferson wrote about our natural, not constitutional right and duty to refuse to comply with unconstitutional federal laws when the national government abuses its power. And we already have that right now without risking our Constitution at a convention. We just need a backbone. COS would do better with their tremendous resources and organizational ability to educate themselves and others on the Constitution we have now. They, as well as ourselves, should insist that candidates not only read but take a course on the Constitution, then test and vet them to make sure they understand the document that they will take an oath to support, just as you did. And above all, we need to hold them accountable to their oath. I have never had a satisfactory answer from the COS to the question, if the federal government doesn't comply with the Constitution we have now, why would they comply with an amended Constitution? Why risk our constitutional republic and a rule of law through a process that at best would produce a document that Congress, the President, and the Supreme Court would continue to ignore? Why not just enforce the Constitution we have now? We ask for your no vote.
Thank you. Anyone else opposed? If you could come forward, and we're not going to take further testimony, but just give your name and your affiliation, please.
Maybe. My name is Orlene Kurla, and I'm the state president of Eagle Forum of California. And I've actually written a book about this that I'd like to submit for you. And I especially want you to look at the last chapter that gives a scenario what would happen.
Thank you. If you could just give your name and your affiliation, please.
Catherine O'Neill Duran. I am I'm board member, California Eagle Forum, and also a teacher of the Institute on the Constitution, and I oppose this bill.
Thank you.
Yes,
I'm Larry Verga, and I'm one of the co-founders of the Sutter Buttes Tea Party. We love Shannon Grove to death, but we do oppose AJR 30.
Thank you.
My name is Carla Verga. I'm with the Sutter Buttes Tea Party, and I oppose this AJR 30, which is supported by George Soros.
Thank you.
Becky Bowen from Yuba City, also from the Sutter Buttes Tea Party. I oppose this bill.
Sarah Foster. I'm unaffiliated, except I'm a longtime resident of California, originally from Pennsylvania, and in strong opposition to this resolution.
Thank you.
Karen Klinger, member of Eagle Forum. I oppose AJR 30. Love you, Shannon.
Thank you.
But I oppose this one, and thank you very much. Bye.
Anyone else in opposition? All right, seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner.
Nobody else will. All right. Two questions. One for Mr. Meckler and Ms. Grove's side, and Shannon, my former seatmate, knows I share the Sutter Beach support for you personally. You and I have sparred on this bill a couple of times, and I'm coming around. So I have a question for Mr. Meckler, and I also have a separate question for the Eagle Forum folks, because I think, frankly, both make good points and both are off base. And specifically with Mr. Meckler, you're whistling past the graveyard, sir, when you suggest we don't need to worry about a runaway convention, or somehow that question has been answered already and you don't need to address it. You do. It remains, in my mind, a serious question, and I'll give you some historical examples, which I have shared with the author. The resolution of the General Assembly of Virginia, January 21, 1786, that is the resolution that allowed Virginia to send delegates to the Constitutional Convention. I quote from it: resolved that, and then it names a bunch of folks, including James Madison, be appointed commissioners who shall meet such commissioners of the other states of the Union to take into consideration the trade of the United States, to examine the relative situation and trade of the said states, to consider how far a uniform system in their commercial regulation may be necessary to their common interests and their permanent harmony, and to report to the several states such an act relative to this great object being trade reform, as when unanimously ratified by them, not by 2/3 or not by 3/4, unanimously ratified by them, will enable the United States Congress effectively to provide for the same. The resolution that Delaware passed, sending delegates to the original federal convention, therefore being enacted by the General Assembly of Delaware.
Vice Chair, you're granted permission to read.
Thank you for that permission to read. I'm making this up as I go along. In devising, deliberating on, and discussing such alterations and further provisions as may be necessary to render the Articles of Confederation adequate to the exigencies of the Union. And then what did they do? They got away from the unanimity requirement. They got away from the trade. They did a wholesale rewrite of what was then the governing law. Now, frankly, we got lucky as a nation because they did, in my mind, a fantastic job. It's true we don't live by it as much as we should. But tell me, given the only historical example we have, why we can just say don't worry about a runaway convention, because we saw our founders did it, and I have no faith that those we send now will be anywhere near as wise, as learned, as scholarly, as dedicated as those folks. Why take this risk?
Sure. First of all, to address the wise and scholarly part, there were certainly wise and scholarly men at the original convention, but if you read the actual history, there were some pretty scurrilous characters there, too. The founders understood human nature as well as anybody. They didn't expect, they said if men were angels, there would be no government necessary among men. So you had all types at convention. You had people that were there to protect their financial interests, the financial interests of their particular state, as opposed to having some, broad idea of what liberty should be. Be that as it may, there were incredible men at that convention, and I agree with that. So let's go back and look at the history. The first thing you read from is actually not for a commission for delegates to the Constitutional Convention. It's actually for the Annapolis Convention. And so the Annapolis...
This is
Yes,
not
sir.
a history debate. If you could answer the question about why you think...
Sure. So the answer is the historic history you're laying out is 7 states actually gave their commissioners in the commissions direct authority using the exigencies language, saying to take all actions necessary to render the federal constitution adequate for the exigencies of the union. And I'd refer you to our website, which has actual
trade and
no. Actually, if you read, and I'll. With all due respect to Assemblyman Wagner, I'll send you the actual commissions, photos of the actual commissions, and you could read the language. All but 2 states gave full authority, and those 2 didn't end up voting in the actual convention itself because they lost their quorums at the convention.
The Federal Convention and the Formation of the American States, edited by Winston Solberg, has provided the original documentations, which I'm capable of going back to.
Sure, no problem.
All right. Tell me why we don't need to worry about a runaway convention.
I'm just going to give you the short answer, starting with the end game, which is no matter what happens at convention, and there are all kinds of limitations all along the way. I don't want to waste the committee's time with the history and the legality element, but in the end, it takes 38 states to ratify any amendment, which means that it takes only 1/4 of the states to stop anything that you or I might not like, or folks on the left might not like. That's the bar that was set by the founders. It's an incredibly high bar, and if you look at the states today, it's impossible to pass anything that's not absolutely mainstream. We had the League of Women Voters say it should only be things that are pressing, that have been outstanding, acute, and abiding. How about $19 trillion in federal debt never addressed? How about 140 to 200 trillion in off-book liability, right? So we have long-term problems.
Understood, and that's a question for the Eagle Forum. That's not an issue with respect to the runaway state. But you miss, or the runaway convention, but you miss, I think, the point. There's evidence that it was supposed to be unanimous. You're saying it's 3/4. What's to stop 2/3 of the states from getting together and saying, we've got a majority, our 2/3, no, it's not 3/4, but we're going to live under these new rules. You can't stop them once you let this genie out of the bottle.
Assemblyman Wagner, you only posit part of the history, what actually happened, and the reason that ratification number changed. It was sent to Congress first for approval, and then sent to the states for approval. The states had to approve the new ratification method before ratification.
Again, we're not arguing the methodology. His question was about the runaway convention. Why would that...
Yeah, and I'm responding to the historical analogy. He's making a historical analogy. I'm just pointing out the incorrect history because that is the answer.
The answer is the incorrect history on the historical.
All right. Very well, we can differ on that one. The question I have for the Eagle Forum is actually, frankly, to my mind, a little bit more serious. And one of the reasons that I've eventually, I think, come around to and will probably today support the resolution, though I am profoundly disturbed by its implications. But the problem they identify is a good one. We have a rogue government. We have an executive that says just recently, when dealing, say, with immigration issues, hey, I can't just change the law with respect to undocumented young people who were brought here by the parents. That's not the way it works in this country. And within a year, he's done precisely that through executive order. We have an executive who is not willing to follow the Constitution as written, and as you say, is the great savior. We have a Supreme Court that many of us will differ. Some on the left think the Citizens United case is awful. Some on the right will, pick any number of cases. What do we do with a government, a Supreme Court, that just will not follow what's written? And the answer, well, elect people who will follow what's written, is a great civics point, but an absolutely unreal practical point when you have a government that's gone rogue. How in the world, short of this convention, do we fix that?
Well, the founders have given us ways to fix that, and it is not an Article 5 convention. An Article 5 convention is the answer to we have to do something. Well, that's not the something, because we still need the rule of law. We may not be following it, but we don't want to lose that Constitution. There is vetting candidates, like Jan said, electing faithful servants, making sure they follow their oaths of office, holding them to it. Nullification is refusing to comply with unconstitutional laws. The states can stand between us and the federal government. The founders have said if the law is unconstitutional, it's no law at all. That's why we need a backbone. School boards could stand up, local governments, and like individuals like Martin Luther King or Rosa Parks on the bus. They refused to comply, and things happened. But to risk the Constitution at a convention when all you're going to get is something else that will be ignored. You see, the courts and the federal government, the courts and the executive that you mentioned and Congress, they're all the federal government. The courts issue opinions, and we say, look at all their opinions. We don't need to comply with what is unconstitutional. We need to stand up to it. And the bodies like you and the local governments and the school boards need to stand for the people, and the people could stand too. But this isn't going to solve the problem. And I did want to say one other thing, that in convention, the delegates can do whatever they want because they have that inherent power, so I wouldn't necessarily call it runaway. They have the right to do whatever they want, throw out the Constitution, put in a new one, change the ratification process so that it isn't 38 states anymore. That's our safeguard. They could change it to a referendum called by the president, like the new state's Constitution is waiting to do, or the signature of the president.
Right. So to get back to your answer, we just need to say no to unconstitutional laws.
Yeah, and also...
And I think that I would love to see that happen, but we are years and years past that solution, and you're going to find the marshals at your door if you try to do that. I mean, we've seen several states suggest there's a problem with the Obergefell decision on same-sex marriage. That's a great policy dispute, but when a Supreme Court judge, I think it's in Alabama, tries to stand up to that, he's met pretty forcefully with the military might of the United States and quickly back down. So your solution, again, is a great civics argument, but unfortunately the only practical solution I see out there is to take what to me is a roll of the dice on the Constitutional Convention, because we have lost that ability to stand up to that authority.
There is one
unfortunately.
One other
All right,
thing.
hold on. Yeah, he did not have a question there. Other comments, Mr. Gallagher?
Yeah, first of all, I want to say I very much agree with the motivation behind this resolution. And Mark, have a lot of respect for you, very knowledgeable on these constitutional issues. And Grant, right? Great job. 16 years old, coming up here and testifying in front of the Assembly Judiciary Committee. I think that's very laudable. And hey, spread the word, spread your knowledge to your friends in high school and elsewhere. I think that whether we're left or right, we should be concerned about the expansive growth of the federal government beyond what its jurisdiction is. And I think one of the things that we've done over time that is really dangerous is when we like the outcome, we're okay with federal overreach. And we sort of excuse it as, well, I like the outcome, this is justice in my eyes. However, the problem is that federal government continues to erode. And, I'll use the example of, a lot of on the right are concerned about the infringement on the Second Amendment, and we bring that up quite a bit. But because people on the left like the outcome, they're okay with it. How about if it's an infringement on the Fourth Amendment, illegal searches and seizures? How about if we start infringing on people's religious freedoms and their free speech in the First Amendment? If the federal government continues to expand its powers, now we're talking about waters of the United States, which is a huge expansion of federal authority, way beyond anything that would be allowed under the Commerce Clause or any other thing you could point to in the Constitution. but we're going to allow that federal overreach. Congress is pushing back on it right now. There's attempts to try and roll that back, but that was done by a regulatory body who's not elected, who has no accountability to the people, and we're seeing more and more of this. So whether you support this resolution or not today, what I hope the message comes out is that we should be concerned about federal overreach. And we should be looking at, does the Constitution allow, the states were meant to be the places of experimentation. Let California do what it thinks is right in one area. Let, Nebraska, I think was brought up earlier. Let Nebraska do what they think is right, and let's see what is the best. They were meant to be the laboratories. And I think it's harder and harder for states to be those laboratories because the federal government is establishing sort of one-size-fits-all policies. My example would be Obamacare. And obviously those on the left would disagree with me on that. But again, you're establishing a one-size-fits-all policy for health care, whereas states could decide to do things differently, and let's see what actually works in terms of getting people the best care, access to care. So I think we should rightfully be concerned about the growth of federal power and our sort of acquiescence to its growth on the right and on the left. However, for me, this is not the right answer to get there, and the reasons are, and I think this was a very well done analysis, by the way, from the committee on describing, some of the constitutional arguments and the scholars who disagree on this. I think there's a very big gray area as to what would happen if there was a constitutional convention called for by the states. Who would control it? What would be the parameters? We can say in our resolution from California, these are the parameters, but is that ultimately what would be happening? I don't know that I can feel confident that that is what would govern the day, and so I have some concerns there. And I guess maybe more selfishly, as much as I love my colleagues in this body and I have the utmost respect for them, we don't always see things eye to eye ideologically, and I'm in the minority here. So actually, David Achu and I, we agreed here on the state bar. That's like the first time in a long time that we've agreed on anything, but so there must be something right about that if we agree. But we don't agree ideologically, and I can't feel confident that those who would be selected as delegates, if this were to pass, would have the same philosophy that I have about how the federal government should be more limited, or not. More limited is not really the answer. It's actually just limited to what the Constitution says it can and cannot do. The federal government has enumerated powers, and we've gone way beyond that. But I'm not confident that the delegates who represent my state are going to carry that same philosophy to this convention. And so, for me, I just don't think this is the right answer to get there. However, I do think that all of us should stand up for states' rights and for a limited federal government that does only what it is enumerated and keeps to its jurisdiction, so that this beautiful government that our founders wisely created can work to its best ability. Thank you.
Other comments? I guess all this debate's been about the authority or the role of the federal government. We are a federation of states, and the Constitution, by its definition, is a constraint on federal power. So what this resolution does is literally put on the table the entire Constitution as it is a constraint on federal power. And at best, we would have lots of delegates showing up and probably not agreeing on anything and have just a tremendous waste of time, which is why other calls have been for specific changes to the Constitution that I can understand. This is so broad that I don't understand how it accomplishes anything that's articulated that it's supposed to accomplish and puts literally everything on the table. And some changes to the Constitution I would agree with. Mr. Gallagher and I might not agree on specific changes. I think he's made that very clear. But on others, we're going to disagree, and I just don't see as a practical matter how this furthers the intended goal or any part of that. And that's why I've made a no recommendation on this. and even this conversation, most of what we're talking about is not, I don't think is actually addressed in the way that this convention is structured. So, with that, Ms. Grove, you may close.
Thank you, and thank you for the conversation. I really do appreciate it. You know, this was a difficult issue for me as a conservative and considered what they call the Tea Party darling to take on, because it did divide the conservatives. You have, Mark Meckler and David Barton and Randy Bennett and many others that are very, very conservative on one side, and then you have Eagle Forum and others that are in the Tea Party in Reading and Sutter and all those that are just as conservative. And so it did divide the conservatives, and that wasn't my intent. My intent was to address the issue with the federal government being a runaway government. My intent was to give the states a right. And yes, I can see from my conservative colleagues' point, one vote for each state, and the individuals in that state elect that individual delegate to represent them. We will not have a vote on the conservative side for California, but there are many other states in which the vote would be counted, which I think would bring some type of resolution to the issues that we face with the federal government. There were comments on the opposition side. Judy, I love you. I think you're wonderful, and I know we've had many conversations. Where Judy says that that the 10th Amendment is there for that purpose. There's no teeth in the 10th Amendment, and it doesn't give the powers to the state that it actually needs, or the states are not executing those powers that's granted to them. There was the argument that they're not abiding by the Constitution now, and we need a Rosa Parks, or we need a Martin Luther King, or we need somebody to stand up and make that fight, or a Cesar Chavez to stand up and make that fight, because the federal government is overstepping its bounds completely. Well, I'm Rosa Parks today, and they're overstepping its bounds today, and we need to stand up and say no. It needs to stop. It definitely needs to stop. So I guess my argument to all of you, or my request to all of you, is to support it so that we can join the other states that are already passing this piece of legislation in order to regain back what the federal government is stealing from us as a state, and as the next generation testified today that they're taking from them. So I would respectfully ask for an aye vote.
Thank you. We have yet to have a motion. There is a motion. Is there a second? Second. There is a second. Call the roll, please.
Stone?
No.
Stone, no. Wagner?
Aye.
Wagner, aye. Alejo? No. Alejo, no. Chow? Chu? Chu, no. Gallagher? No. Gallagher, no. Garcia? No. Garcia, no. Holden? Mainshine? Aye. Mainshine, aye. Ting?
You have 2 votes, and there are members missing. We will put it on call.
Thank you very much.
Thank you, Mr. Chairman.